Hello, my name is Emily Hendrickson, and this is my compare and contrast for contract terms. First, we have offer versus acceptance. An offer is an official proposal, often accompanied by a set of terms. Acceptance is just the simple agreement to the terms. An example for offer is a man makes an offer to sell another his car for $3,000, and then acceptance is the second man agrees to buy the car at that price. Next, we have bilateral contract versus unilateral contract. Bilateral is a contract containing two promises, one made by each party to the contract. An example of this is a student offers to sell their laptop to another for $400, and the prospective buyer states their intention to buy the laptop. A unilateral contract is one where only one party makes a promise. So an example would be a woman offers a $100 reward for the return of a lost cat. Express contract is one in which the terms of the contract are stated by the parties either orally or in writing. An example would be a landlord and tenant sign a document outlining the rent, lease duration, and rules. An implied contract is one in which the terms of the contract are not stated by the parties, but their behavior shows them to be in the contract. An example would be you enter into an implied contract that you will pay for the meal once it is served at a restaurant. Executed contract is the status of contract reaches once both parties have fully completed their duties. So an example would be a student agrees to buy a textbook from another and pays $50 to the setter, completing contract. An executory contract is when a contract is in existence but not yet completed. For example, the same student agrees to buy the textbook on a Monday but cannot pay until Friday, therefore the payment is not done. A void contract is an agreement that is not legally enforceable from the moment it is created, often due to a fundamental flaw. An example of a void contract is a contract with a minor because of a lack of legal capacity. A voidable contract is one that may be avoided or gotten out of due to some rule of law or the wishes of one party. If one party provides false information to induce the other party to sign, the contract is then voidable. An unenforceable contract is one that is valid but cannot be enforced for some legal reason. An oral contract for the sale of real property is an example of an unenforceable contract because a real estate contract is required to be in writing to be enforceable. An illegal contract is an agreement to perform an unlawful act, making it void and often punishable by law. A contract that violates public policy, like one to sell human organs or engage in illegal gambling, are examples of illegal contracts. Consideration is the exchange of benefits and promises by the parties to the agreement and is an essential component when forming a contract. An example would be a car sale. The seller's consideration is the car and the buyer's consideration is the money that they are willing to pay for it. Past consideration is an act or service that was completed before a promise was made and is generally not valid consideration for a new contract because it wasn't given in exchange for the new promise. For example, a neighbor mows your lawn for free last week. You feel grateful and promise to pay them $50 for their help. However, the mowing was done before you made the promise to pay, making the agreement unenforceable. Capacity is the legal standard for being able to make a contract. For example, a judicial declaration of insanity makes a person incapable of legally entering into a contract. Legality states that a contract must have a lawful purpose and be in compliance with all relevant laws to be enforceable. For example, an accountant is paid by a business for his services. Promissory estoppel is a contract where no consideration is necessary when someone makes a promise that induces the other person's detrimental and reasonable reliance on the promise. An example of this would be a store owner who agrees to sell an employee their business after retiring and then suggests that they get a 4-year business degree. The employee then takes out student loans and completes the degree only for the owner to refuse to sell. A quasi-contract is when a court imposes a contract on the parties when one actually does not exist or when an express contract cannot be enforced to prevent unjust enrichment. For example, a delivery person mistakenly delivers a pizza to the wrong house, and the resident knowingly accepts and eats the pizza without having paid for it. The court may impose a quasi-contract to require the resident to pay the delivery person or company for the value of the pizza to prevent unjust enrichment. A material breach occurs when a major or essential part of the contract has not been performed. For example, a man agrees to sell his car to a coworker and receives payment for the car, but the man who owns the car does not provide it to the coworker. A minor breach is when a party fails to fulfill a minor, non-essential obligation, but the contract's overall purpose is still met. For example, a contract that exists between a supplier and a business sets a weekly delivery for Monday, but the supplier fails to deliver until Wednesday. The delivery still occurs even if it wasn't by the due date. Next, we have a condition precedent, which is an event that must first occur before an agreement becomes effective. An example of this is insurance policies have condition precedents that a fire must occur before the insurer is obligated to pay for damages to a home. Next, a condition subsequent means that a contract or agreement can or will be void and will end if and when a particular event or action occurs. An example would be an insurance policy may have a condition subsequent where coverage is terminated if the policyholder fails to pay premiums. Compensatory damages are awarded by a court equivalent to the loss a party suffered based on the proven harm, loss, or injury suffered by the plaintiff. An example would be a construction company fails to complete a project on time, which causes a business to lose wages. Punitive damages are awarded in addition to compensatory damages in certain circumstances, such as when the defendant's behavior is found to be especially harmful. For example, a contractor agrees to perform a renovation but lacks the necessary qualifications and falsifies their experience on the contract. Liquidated damages are those that are agreed upon or predetermined by the parties at the time of the creation of the contract, in the event of a subsequent breach. An example would be a construction contract for a new office building includes a liquidated damages clause of $1,000 a day for delay. Penalty clause is a contractual clause that imposes liquidated damages that are unreasonably high and represent a punishment for breach. A landlord leases an apartment to a tenant for $1,000 a month, and the lease provides that if a tenant holds over, the tenant must pay $750 per day. A specific performance is when a court orders the breaching party to do that which they agreed to do according to the terms of the contract. For example, a court orders a seller to complete the sale of a unique art piece after they breach a contract where they agreed to sell. Rescission is the cancellation or undoing of a contract that restores the parties to the positions they occupied before the agreement was made. For example, a manager signs a contract under threat from another party, but can petition a court to rescind the contract. An agreement is a novation is an agreement whereby an original party to a contract is replaced by a new party, creating a completely new agreement and ending the original one. An example would be a company selling goods goes out of business, but it can use a novation to transfer its contract with a customer to a new supplier, transferring all the rights and obligations with it. An assignment is the transfer of a contract right. For example, a general contractor has a contract to build a house and delegates the electrical work to a licensed electrician. The electrician now has the duty to perform the electrical work, and the general contract retains the right to be paid for the work performed. Next, we have a statute of frauds, which is a statute requiring certain contracts to be in writing and signed by the parties bound by the contract for the purpose of preventing fraud and other injury. An example would be the sale or transfer of land. The parole evidence rule is an agreement that is not contained within the written contract. Under this rule, agreements made outside of the contract are inadmissible in court unless there is evidence of fraud, duress, or mutual mistake. An example would be if a written car sale contract specifies a $10,000 price, a buyer cannot introduce evidence of a prior oral agreement to pay only $9,000. An adhesion contract is a form of standardized contract that is entirely prepared and offered. Can you make them shut up? And offered by the party of superior bargaining strength. To consumers of goods and services. An example of this would be software licenses and credit cards agreement, often found in the terms and conditions. An unconscionable contract is one drawn by one party so that the party's lopsided benefit and it must be accepted as is. An example would be a predatory loan with excessively high interest rates. And then lastly, we have mutual mistake versus unilateral mistake. Mutual mistake is a situation that exists when both parties are mistaken about an important or material aspect of an agreement. An example would be a contract to sell a specific piece of property, like a car or a house, can be void if both parties are unaware it was destroyed before the contract was signed. Unilateral mistake is when only one of the parties makes a mistake as to a material element of the contract. For example, a company offers to sell a product for a price that is a clear error, and the other party accepts knowing the price is too low. And then lastly, here are some key takeaways. Found on slide 2, something that we can take away is an offer initiates the process of creating a legal contract, so it is the first step. And then the second one found on slide 5 is an executory contract is one that is still in progress, while an executed contract is one that is already completed. Found on slide 9, capacity refers to the legal standardizability to form a contract. Fourthly, found on slide 12, sometimes a contract includes a conditional precedent that requires an event to occur before activating, which that would be insurance, essentially. Slide 14 has liquidated damages are predetermined in the contract. And then lastly, agreeing to the terms and conditions section of an online service is an example of an adhesion contract found on slide 18. And then here are my references.